The Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, hearing of the appeal in the matter BBCV2022-001 between Apsara Restaurants, Barbados Limited, and Guardian General Insurance Limited. Members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Witt, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, the Honorable Mr. Justice Burgess, and the Honorable Mr. Justice Jamadar. Counsel, you may now enter your appearances.
May it please you, my honors, my name is Roger Ford, and I appear on behalf of the respondent, and with me is Mr. Anthony Ordain Casey.
Good morning. Mr. Mendes, we didn't hear you. I think you might have been on mute.
Are you hearing me now, Your Honor?
Yes, very much so.
Yes, very much so. Yes, I said that I'm Douglas Mendes, appearing for the appellant, and I'm leading Mr. Clay Hackett, who is with me in the room.
Yes, thank you. Are you ready, Mr. Mendes? You can proceed.
Thank you very much, Your Honor. If I may, I will deal with the non-disclosure issues first, and I would make this submission that the courts below were wrong to proceed on the basis that the question of a cancellation or the denial of a claim simpliciter is something which must be disclosed as being material to a prudent insurer. And instead, they ought to have held that what was important were the reasons why the policy was cancelled, or the reason why the claim was denied. And it is only if those reasons go towards the moral hazard of the insurance, then or the risk, then it becomes something that is material to be disclosed. In that regard, in our written submissions, we have made reference to Montgomery on insurance law and some other authorities. And if I may, just share with you a couple of references in that regard. I have Mr. Hackett has his computer on, and he is able to share if that would be convenient to the court.
Yeah, sure.
So I'll ask him. This is to be found at page 3626 of the bundle, of the electronic bundle. If you look at the right-hand column on the screen, Your Honor, towards the bottom, there's a paragraph 2, and just below that, you will see the 4 sentences down. This is what the judge said. All the evidence discloses is the fact that there was a cancellation.
Just a minute. Just a minute. You said page 3626?
3626. Yes, please, Your Honor.
Mr. Mendes, can I also ask Mr. Hackett if he is capable to highlight this, because it's up on a big screen in the court.
Yes.
As you know, we're sitting in Guyana. Could you ask
Yes.
Mr. Hackett to just highlight the parts that you are focusing on for us? So that'll help us.
Yes, he's trying to do that now.
Thank you. Yeah, great. That's fantastic.
So it starts there and it goes to the bottom. So basically what I was reading was all the evidence discloses the bold fact that there was a cancellation, by whom, how, under what circumstances is not known. There may very well have been a cancellation under circumstances making it clearly not a circumstance material to be known to the company. Indeed, the only reason for the cancellation which was given was that Glen Falls company did not insure livery cars. a matter of policy on the part of the company and not a circumstance material to be made known to the defendant. Something more than the mere fact that there was some sort of cancellation must be shown. Materiality must be really proven and will not be assumed. The defendant has not shown as a matter of fact the cancellation was a circumstance material to be known to the company. And in similar vein is the decision of the New South Wales Court in Barclays Holdings against
Mendes.
British National Insurance.
Mr. Mendes, sorry.
I'm sorry, Your Honor.
Yeah, before you leave that case, could you tell us or show us the date of the case? Because it appears to me that this case predated Pan Atlantic.
It's a 1923 decision.
That's what I thought.
Yes.
And the further question I'd raise is, would that statement after Pan Atlantic, would it still be good law?
Well, what I'm asking this court to find is that that is the test that ought to be applied. And I'm referring to these authorities. And the Barclay case is a later case. It is a decision I don't have the date there, but it is a later case.
It's 1978.
It is a 1988 case, I think.
1978 or 1988, that's quite correct. But that's
Yes.
Pan Atlantic as well. The question I'm raising with you at the very beginning said that you were going to apply a test.
Yes.
I don't know, you haven't indicated to us the nature of the test that you are going to apply.
Your Honor, it is the normal test that it is to be applied. I'm not asking you to differ from it, but it's the application of the test that I'm questioning. And I'm saying that in applying the test, I'm sorry.
Sorry, Mr. Mendes. I'm not quite certain what test we are applying.
Oh, I'm sorry. Your Honor, it is the test that there's no dispute as to the test. The trial judge applied the test in the court below, and if I can refer to it, I'm sorry, I don't have it. I don't have the actual wording in front of me, but I will refer very quickly to what you said, and it is the Pan Atlantic test. A fact would be a matter is material if it would influence the mind of a rational underwriter governing himself by the principles and practices on which underwriters do in practice act. I'm reading from paragraph 32 of the judgment of the trial judge, which is at page 694 of the electronic bundle.
Sorry, am I right? Sorry, Mr. Mendes, I'm sorry to,
yes,
but I need to be located in the test that you're applying. Am I right in believing that Pan Atlantic disclosed two tests? A test by the minority and the test of the majority. Am I right in reading Pan Atlantic as disclosing these two possible tests?
Well, the one that I am referring to, which I understand to be the non-controversial test, is the one that it is material if it would influence the mind of a rational underwriter governing himself by the practice. And the only point that I'm making is whichever test is to be applied, I don't have the actual wording of the minority as compared to the majority. My point was a different one. I'm saying that in whichever test that is to be applied, when you're dealing with decision whether to accept or not accept the risk, and not when they merely suggest that there be delay for further inquiry, the circumstances must be revealed by the proponent with sufficient detail to enable the underwriting determination to be made. Conversely, if the previous occurrence exposed in this circumstantial detail could not affect the mind of a hypothetical underwriter, there is no obligation to disclose it. It follows that if the assured, knowing the full facts but misjudging their materiality, fails to disclose them, the policy can be avoided. If, however, the insurer proves only the suspicious part of the circumstances, and the full story is proved by the plaintiff discloses no moral or physical hazard, and for that reason, no materiality, the defense will fail. And then in the paragraph which follows, which I won't read, but I will ask Your Honors to read in due course. The court goes on to say why the fact that there was a prior loss by fire and that there had been a letter to the insured suggesting that they not renew the insurance, but was on some innocent basis. The court in this case held that those facts were not material to be disclosed.
Sorry,
because
I'm sorry, Mr. Mendez. I think we lost a lot of what you said earlier. You were in dialogue with my brother Burgess, and
yes,
you were
John.
seeking to locate your submissions in relation to the test, which is to be applied. Yes. And I think you pointed out that in the Pan-Atlantic case, there were two tests, one by the majority and the other by the minority. You were responding to that question when, unfortunately, we lost contact. So we missed...
Oh, I'm terribly sorry.
No. We missed a lot of what you said. Is it possible to recap very briefly, please? Thanks.
Yes. The point that I was making, Your Honor, if I may say at the moment, I'm not seeing you on screen. So I'm not too sure if the cameras are not on. But I'm not seeing you on my screen.
We are hearing you perfectly well. Thanks.
Okay, thank you very much. The point that I was making, Your Honor, is that whichever test is to be applied, the minority or the majority in the Pan-Atlantic case, I'm saying that when one is considering whether a cancellation is material, and I've extended to a denial of a claim is material, that what one must consider in applying the test is the circumstances under which the cancellation occurred, and likewise the circumstances under which the denial of the claim occurred. I'm saying in applying the test, that is what the court must insist upon. Sorry, or you may have circumstances in which the cancellation occurs in... I'm sorry, Your Honor.
Yeah, I don't want to pursue the point too much, but I believe that this case is a seminal case. It's a case which has implications for this court, and that's the reason why I was trying to get some clarity as regards the two tests, because in Pan-Atlantic itself, the two tests produce different results in the view of the majority and the minority. So I am not certain that I understand when you say it doesn't matter which test you apply. It appears to me that it does matter which test you apply.
Mr. Mendez, if you allow me to put something else into the mix with that, because I thought I heard you earlier say that the test was not in dispute. So I thought that you had, there was by the trial judge a test that trial judge used, and then the Court of Appeal accepted that test, and I understood then that you were saying to us that you and counsel on the other side, Mr. Ford, you were of the same view. That is how I picked it up. So I want to put that in the mix, if I may, my brother.
Yes, Your Honor. So the point is that I was saying that and this is why I'm not ready to, and I don't have in front of me the different formulations of the test of the majority and the minority in the Pan-Atlantic case. And this is why my point was that as far as the accepted test is concerned by the trial judge and the Court of Appeal, the question that we are raising is more to do with the application of the test to the circumstances of a case. And in particular, when we are dealing with a question of a cancellation, I'm referring the court to authorities that say that what is of concern is the circumstances under which the cancellation took place, or the prior loss took place, or the prior non-renewal took place, etc. so you may not have heard me reading from it. So I'll ask Mr. Hackett if he put it back up on his screen, please.
Yeah, Mr. Mendes, you dropped off a little bit again. So
this is from the judgment of the New South Wales Court of Appeal, Justice of Appeal Glass. And he said, and this is what he said, if circumstances are material,
Mr.
when
Mendes,
they bear upon the underwriter's decision whether to accept or not accept the risk, and not when they merely suggest that there be a delay for further inquiry, the circumstances must be revealed by the proponent with sufficient detail to enable the underwriting determination to be made.
Okay, Mr. Mendes. Mr. Mendes.
Yes. Yes, Your Honor.
I think I understand the point that, well,
yes.
The point that you're making is that if either of the Pan-Atlantic tests is used, each one, when it is applied, would require an interrogation of the circumstances in which, in an instance like this, the cancellation was effected. That's the point that you are making.
That's correct.
Yes.
That is the point.
And that, in your view, in either case, using either of the tests, applying either of the tests, the circumstances of this cancellation were such that it could not be material using either of the tests.
That is correct.
Yes. So you could move on beyond that.
Thank you.
Yes, before you move on, please, I wanted to maybe say a couple of things. One is that we understand the point that you're making very well, as the President just summarized. No difficulty with that. But secondly, you would appreciate, and I think that this may have been at the background of the question raised by my brother Burgess, that one of the functions of the court is to provide guidance to the lower courts and to attorneys, and therefore it's important for us to clarify what the test is. Now, it seems to me that we might be making a bit of heavy weather of this, because there is no doubt that in a case later than Pan-Atlantic, that is to say in the Joseph and Clico case, the Barbados Court of Appeal made very clear what the test was. Sir David Simmons adopted the test of the majority in Pan-Atlantic. So would you not agree with me then that it is settled that that is the appropriate test for application in these circumstances?
If I may put it this way, Your Honor, because there has not been any dispute between the parties at any point in time as to exactly what the test is, you will see that my submissions have not in any way focused on the competing tests. My submissions and the case of the appellant before the Court of Appeal and before this court has focused on the application of the test.
Yes, Mr. Mendes, I'm sorry. I understand where your focus is.
Yes.
But I'm trying to indicate that the reason for the question is the explanation I gave earlier. Now, if you agreed with me that the majority in Pan-Atlantic enumerated the test, would you not also agree that there are two stages to that test? First is that of materiality, and the second stage is that of inducement. Would you?
Yes, Your Honor.
Would agree with that? Okay.
Yes, Your Honor.
Thank you very much.
So, Mr. Mendes, if I may?
Yes, please, Your Honor.
You would be content with a judgment, and you would consider that the appropriate course for this court to take is that while it is an interesting academic question, there is not any need for any determination as to which is the preferred test and which one this court will apply, because on the basis of the application of either, your proposition remains the same. You have not fully argued it, and you therefore do not wish to make any submissions in that regard. And it seems to me further, Mr. Mendes, fundamentally, your case is that there was not any cancellation. So as far as you are concerned, you are arguing this, that if there was a cancellation, which you do not think there was, then this is what should be considered. But what you're saying is that as a matter of fact, there was not any cancellation because no policy was issued. The insurer in that case simply treated it post facto as a cancellation for the purpose of its internal record of justifying the payment out of a sum of money. Am I correct?
Yeah, yes, Your Honor. I think you've saved me a lot of time there because that is essentially the case. And ultimately, what the point that we are making is that this particular cancellation, if I can put it, cancellation in inverted commas, posed no hazard because the Gulf Insurance had made it clear that they were prepared to insure the Omera company. But the cancellation occurred in the circumstances of, again, cancellation in inverted commas, occurred in the circumstances where there was a withdrawal of authority, as it were, that there was a mix-up as to the authority of the broker, etc. So that it wasn't cancelled because, for example, there were too many claims or that there was some breach of the contract or something of that sort. There was nothing going to the moral hazard. And for that reason, even if there was a cancellation
Mr. Mendes,
proper,
Mr. Mendes,
it was not material.
For purposes of clarity, you continue to make the submission on the basis that even if there was a cancellation. But
That is correct, Your Honor.
I think your better course in terms of the case that I see presented by you on paper is that there was, as a matter of fundamental truth and fact, no cancellation.
In essence, yes, there was no cancellation, but we have to admit the facts before the court, which is that there was a debit note issued by Gulf Insurance, which had a policy number, and then there was a credit note reversing that debit note, which also referred to a policy number, and so on. But the evidence was that a policy was not, in fact, issued.
So what they had
Yes.
is, as we do in law, they created, in fact, a fiction.
It was something that was entirely on their books, on the paper. There was a debit, and therefore you had to reverse it by a credit. That's effectively what happened. But no money passed.
So to put the matter in forensic terms, and applying the test, which is applicable, indicated by Sir David Simmons, you would say then that the fact you're speaking about was not material.
Precisely.
Precisely. So the first
yes,
stage of the test was not satisfied.
Yes, but the point that I'm making, Your Honor, forgive me for belaboring it, is that in order to determine whether it was material, you had to go beyond the simply ticking the box there was a cancellation or there was a denial of a claim, and you had to go further to find out the reasons for the cancellation in order that you could judge whether it was material. But I do, of course, take His Honor Justice Barrow's point that at the heart of our case as well is that this was not a real cancellation because there wasn't really an issue of a policy.
Yes,
So,
I think
our
you
case is
should
on
pass
both
on.
limbs, essentially.
I think you should pass on to the next point, Justice.
Thank you very much, Your Honor. The next point is in relation to the maritime claim, and for that it's necessary to refer you to the pleadings, and you will see the amended defense at page 1115 of the electronic record, and I'm referring you to subparagraph B on that page, which I'll ask my friend Mr. Hackett to highlight. And the pleading was that the said Omera Foods Product Limited had made a fraudulent and or baseless claim against its insurers Maritime, and that the same were dismissed by the Supreme Court. So that was the pleading. And then particulars of that pleading were given. And that's the next page. I'll ask Mr. Hackett to go to the next page. So those are the particulars that were requested under paragraph 8, and the answer that was given was, in or about the month of April 1995, Omera Foods product, which was managed by Mr. Sharif Mohammed and his wife, Mary Kavanaugh, sold 2 containers of shrimp. Grace Kennedy, on the 16th of June, the Public Health Department seized this shipment and certified it not fit. And if you could drop down to the paragraph, on return of the spoiled shrimp to Trinidad, Omera Foods product insured the said shrimp with maritime insurance. On the 24th of October, Mr. Mohammed reported to the insurers that someone had broken into his business and had damaged the compressor to the container which stored the shrimp. Omera Food Products made a claim to the said insurance for spoilage of the said shrimp. So essentially, the pleading was that Omera Food Products had insured spoiled shrimp that had been returned from Jamaica. And if you look at the trial judge's judgment at page 709 at paragraph 92, next page, this is how she describes the issue at paragraph 92. At the trial, the defendant sought to establish that Omera Food Products Limited had insured 2 containers of spoiled shrimp, which had been rejected and returned by a purchaser in Jamaica. The defendant's allegation was that having insured the containers of shrimp, Omera Foods had attempted to claim against the insurance policy, and the claim was refused. Now, the judge never made any finding that the appellant had in fact insured the spoiled shrimp. And in fact, there was evidence from Mr. Mohammed that when the shrimp was returned, and you will see that at page 1070 to 1071, going on to 72. I won't read it. It's paragraphs 46 to 51, in which in detail he spelled out what happened to the shrimp when it came back, that it went into public storage, and the supplier from Guyana had taken possession of it. So there was evidence, and I should say there was no evidence from the respondent that the appellant had, that Omera had in fact insured the spoiled shrimp. And then the judge, having looked at the pleadings in the case, because Omera had brought proceedings against Maritime, had found at page 710 of the record in paragraph 100.
Sorry, Mr. Mendez.
Yes, Your Honor.
Sorry. In your written submissions, you had attempted to lead this court into examining the facts found by the learned trial judge.
Yes.
You had concurrent findings of facts by the Court of Appeal and by the trial court. It seems to me that you must have a legal basis for inviting this court to do what is being done. I think that the jurisprudence is that this court, where their concurrent finding of fact, will only do so in exceptional circumstances. But you're taking us through the facts as though that is the function of this court.
No, Your Honor. What I'm saying is, as a matter of fact, I'm not, in this regard, I'm not challenging the finding of fact of the trial judge. I'm pointing out that the pleading was that the appellant had insured spoiled shrimp. The judge had identified that as the defense, and that as the case of the respondent. And I'm pointing out that the judge did not find, made no finding that the appellant, sorry, not the appellant, Omera had insured spoiled shrimp. So as far as the respondent's case is concerned, it was not established on the pleadings. That's the point that I'm making. So I'm not asking you in this regard to contradict any finding of the trial judge. I'm pointing out that the respondent's case was not established on the evidence. And the judge certainly did not make that finding. I'm going also to point out that the judge also found that the pleading had not been established. That is to say, that the claim had been denied on the basis of fraud. And that's why I'm referring you to paragraph 100 of the judge's decision, not to challenge it, but to indicate to the court that she in fact found against the respondent on the respondent's pleading. What she in fact found is, however, whilst the correspondence and pleadings in this claim that was subsequently filed in the Supreme Court seem to suggest that Maritime might have had some reservations about the claim and may have thought it fraudulent, the defense and statement of issues filed in the case clearly do not claim fraud as a defense. So again, their pleading was the claim was denied on the basis of fraud, and the judge's finding that that was not proved. When you look at the pleadings, that in fact was not the case. And the learned judge went on to find that the following paragraph 101 went on to find that the basis of the refusal, you see that added to this, the May 16, 1996 letter from Claims Adjusting Bureau to Amera, signed by Mr. Zui, denying the claim, clearly states the denial of the claim was for breach of condition 11 of Amera Foods' refusal or failure to provide satisfactory or sufficient details. So again, the basis of she found as a fact that the basis of the denial was not fraud, but it was that you had not complied with the condition that you must provide sufficient details. And then there were other issues that arose in the evidence about that the claim was also denied on the basis, and the pleadings in the case demonstrate this, and we have referred to it in our written submissions, that the other basis upon which Maritime had denied the claim was that the insurance policy didn't cover burglary. And the circumstances of the claim was that there had been a break-in and the fridge had gotten affected and so on, and that caused the products to get spoiled and so on. So the point I'm making, Your Honors, is one, that the judge found that the defendant had not established their pleaded case and therefore ought not to have gone any further on this particular point. She did, however, go further to say that the appellant did not disclose the fact that there was a claim that had been denied. Simpliciter. And we make the same point again, that this court ought to hold that in applying the test, it is not enough that you just simply refer to the fact that a claim was denied. You also have to get into the reasons why the claim was denied. But I'm only saying this as a backup point, as it were. I'm saying that the respondent had not established their case on this point, and the court ought not to have gone any further.
You're suggesting that they didn't make the claim as a matter of law. Is that what you're suggesting?
So I didn't get you very clearly there,
Yes.
sorry.
Sorry, that the respondents didn't make their case based on a matter of law. Is this what you're suggesting? That they didn't answer the pleaded case of the plaintiff, of the appellant?
No, I'm saying that they did not prove their own case. They had defended it on a basis that there was not a disclosure of a particular thing, and they had not established that.
But didn't the trial judge agree with you on that point?
Yes, and therefore I'm saying that she ought not to have gone any further. But she did go further, having said that the respondent had not established their case on this point. She then went on to consider it on another point, which was not pleaded. And the other point that she said, they said your claim was denied on the basis of fraud. She said that was not so. It was denied on another basis. And then she went on to say, well, you nevertheless ought to have disclosed it as having been denied on that other basis.
But was fraud the only basis that was advanced? Or was it that it was fraud and baseless?
It was fraud and baseless, but in the particulars, as I have just referred you to, their claim was that the Omera had insured the shrimp that came back from Jamaica having been declared to be unfit. That was the case that they brought.
So wasn't it open to the trial judge to find that the claim was baseless?
Their claim, that is to say the respondent's claim, yes. Their claim was baseless because they pleaded a particular thing, which is that when you ask for particulars, they said, what I am saying, I'm coming to court to say that O'Meara insured spoiled fish that they had gotten back from, which had been declared by the authorities in Jamaica to be unfit. That's the case that they said they were going to make. The judge did not make that finding. And as a matter of fact, as I pointed out, there was evidence to the contrary. And Your Honor, Mr. Mohammed was not cross-examined on that. He was never challenged on his evidence that when the ship came back, it was put in public storage and went to Guyana, the Guyana suppliers. He was never cross-examined on that.
And
but that was their case, and it wasn't proved.
There was no application made to amend the pleadings?
No, there was not.
Yes. Thank you.
So, but again, as I said, my first point is that the respondents, having not established their case, the judge ought not to have gone any further, but she did, and she then decided this part of the case against the appellants on a point that was not pleaded. But I'm, of course,
Mr. Mendez, we follow you very clearly.
Thank you. Thank you very much, Your Honor. The other point on well, Your Honor, I was going to make the point that the learned judge also, but I'll make it very quickly. The learned judge also buttressed her findings on the basis of the Guardian Life's proposal form. And it was buttressed her findings as to materiality on the basis of the form. But the form, she accepted in evidence and she found that the form was in fact not submitted by the appellant. It was not signed and it was not submitted. But she nevertheless went on, and I'm just going to give you the references. At paragraph 79 to 81 and 106 to 108 of her judgment, that's pages 705 to 706 and 712 to 713 of the record, she went on to rely on the proposal form that was not filled out in support of her findings that the bare non-disclosure of cancellation and bare non-disclosure of a previous loss was material.
Mr. Mendez, is this pleadings again, or is this findings of fact by the trial judge?
No, this goes to a finding of materiality, and I'm saying that in finding materiality, she took into account the proposal form of the insurer, and that proposal form was not signed, so it was not something that was available to her to take into account. So this is not a challenge to her finding of fact. This is a challenge to her methodology. In other words, she was not permitted to take that proposal form into account in determining materiality.
Mr. Mendez,
yes, Your Honor.
Yeah, before we pass over so quickly the question of interrogating findings of fact where there are concurrent findings of fact, if the trial judge took into account something as material and that account was erroneous, because if you are accurate when you say that the form was neither signed nor submitted, is that not an error of law? In the sense that it is a reliance on a fact that is a misreliance. What I'm trying to get at, just pause for and just see if we can maybe understand each other on this.
Yes.
Where there are concurrent findings of fact, that is not a bar, is it, to us looking at what was done? If you can show us that whether the trial judge and or the Court of Appeal took into account facts that you can conclusively demonstrate were erroneous or misapplied. Is that not within the area of review that is permitted to us, even if there are concurrent findings of fact?
Yeah, Your Honor, you will see, of course, that our case is that this court ought to adopt a different approach to this particular case because of delay, and therefore you ought not to take the normal approach that is taken to concurrent findings of fact, even beyond the different approach that this court has already taken. But in any event, we have put in our written submissions that the trial judge and the Court of Appeal have committed a number of different errors that would take this case beyond the ordinary case of deference to the findings of a trial judge, one, and then deference to concurrent findings of fact by the trial judge and the Court of Appeal. Because certainly in relation to the Court of Appeal, as we have demonstrated throughout our written submissions, the court either forgive the pejorative term, but rubber stamped what the trial judge did without engaging in any serious analysis, and certainly not engaging in the points that we made as to the errors in the evidence. Sorry?
We have seen those submissions, Mr.
Yes.
Mr. Mendez.
Yes,
So I will ask that you move on to the next point. You've dealt with the maritime claim, you've dealt with the cancellation.
Yes, Your Honor. And so far as
Mr. Mendez, may I? Just
Yes,
to
Your Honor.
confirm for the record, because I have asked for it and looked for it, we have not
Yes.
seen on the record any filled out proposal form, just a blank one.
Yeah, that is the only proposal form that is on the record. That is at page 1588 to 1589. And you will see that at paragraph 36 of the judge's judgment at page 694, she says that the plaintiff in this case did not fill out a proposal form which would have contained such a clause.
Thank you, Mr. Mendez.
Yes, so I'm saying that in any event she would not have the concurrent findings of fact point would not apply here because the judge took into account a matter that she ought not to have taken into account. So if I can move on to the question of indebtedness, because I am, of course, very cognizant of the time limitations. Again, I'm relying on the submissions the written submissions that we have made. What was not disclosed in this case was the fact that the directors of the appellant had a judgment registered against them of an amount of about 300,000 Barbados dollars. And the question, of course, would be whether that was a fact that was material. We respectfully submit that, well, first of all, the trial judge did not give any indication as to why she thought that was material. She just said it was. The Court of Appeal, on the other hand, said that it considered it to be material, and I will refer you to, sorry, I just had it at hand and I lost it. It's at paragraph 50 and 51 of the judgment at page 303 of the electronic record, where the learned Chief Justice said this consideration went to more than just the credit risk of the insured, but clearly would have brought up consideration of priority and assignment of any policy which the insured would be subject to if the policy was ever engaged. And then in 51, a prudent underwriter would wish to know whether any policy issued should be subject to another party as part of the determination of whether they would wish to provide cover for the insured. Now, respectfully, Your Honors, when a judgment is registered, and this is a judgment that is registered in Trinidad, not against the appellant, which is a Barbados company. It is a judgment that is registered in Trinidad against the two directors and another company, that is Omera. And the effect of registration, of course, is that the judgment becomes a charge upon their property. It does not cause any assignment, or it doesn't create any priority in relation to any the proceeds of any claim that might or might not be made against a policy at a later date. So to the extent, respectfully, that the Court of Appeals thought that that was the basis of a finding that the indebtedness was material, respectfully submit that that has to be wrong. The fact that the directors of the appellant and another company owed money to a company in Trinidad and Tobago has no impact upon any claim that might or might not be made under an insurance policy in Barbados. It may be that if there are proceeds of an insurance policy, then the creditor in Trinidad might want to seek proceedings in Barbados if they can enforce the judgment in Barbados to get a garnishee order against the insurance company so that the proceeds be paid directly to them. But that is something that happens all the way later down. Yes, Your Honor.
In coming to that conclusion, can you just remind me, was there any reliance placed on expert evidence as to whether this non-disclosure was material?
There was Mr. Yedden. Yeah, I think it was Mr. Yedden had given evidence, but the learned trial judge said that she was not relying on his evidence at all, because she had found, I'll ask Ms. Ackett to find that part of the judgment where she had said that he had all that he had said is that these were the things that the insurer might be interested in, and not the things that might be material to the insurer as far as the risk is concerned. So she did not rely on his evidence at all.
To clarify one small point for me, the test for materiality.
Yes, Your Honor.
Is that a question of fact, or is that a question of law, or is it one of mixed fact and law?
It would have to be one of mixed fact and law, Your Honor. It, of course, is a question for the court to determine. It is not a question for the insurers themselves to determine, although there may be practices. But ultimately, it is a matter for the court to determine whether a particular fact is material. But it is a question of mixed fact and law, and it is something that therefore, a appellate court is entitled to have a different opinion about than a court below.
Yes, well, that is where I was going, because if it's a matter of law, then the obstacle that you faced earlier about concurrent findings of fact would not apply, clearly.
That is correct, Your Honor.
To the extent it's a question of law, then of course it's a matter, in a sense, for us equally as it was for the courts below. The question of fact, I think, has to do with the inducement issue, as to whether a material fact induced the particular underwriter to enter into the policy. And,
that's correct, Your Honor.
And there, of course, is a separate issue. Thank you.
Yes. But as you'll appreciate so far, Your Honor, is that my attack, if I can use that word, on the judgments in the court below are, first of all, that they applied the wrong legal test of materiality because they didn't take into account the circumstances. Two, that the trial judge proceeded on a case that was not pleaded, which is again another question of law. And thirdly, that there was a finding of materiality, which is something for ultimately for a court of law to determine. And therefore, this court is entitled to have a different opinion and to determine finally whether the mere fact that you have a judgment registered against you is something that is material for the purposes of the law in relation to non-disclosure. So if I may move on again, cognizant of the time, Your Honors, to the condition 11 point. And if I may, as best as I can, summarize the case. And it is important for, first of all, to locate this in the findings of the trial judge, which were not under challenge in the court below, in the Court of Appeal. And this is in the judgment of the court, the trial judge, at paragraphs 306 to 307. And this is at page 758 to 759. And in it she said, she's basically saying that a claim form was submitted on the 6th of September. This is higher up on, I'm sorry, at paragraphs, from paragraphs 303 going on down. But I'll take you to 306, where she says, come down, 306. Where she says, in his witness statement, the defendant's operations manager, Mr. Adams, stated that the plaintiff company had submitted this quantified claim to the defendant on October the 4th, approximately five weeks following the loss. Under cross-examination and trial, he agreed that the defendant company had received the initial claim form on 7th September and the detailed information on 12th September when it was submitted by Lynch. The evidence disclosed that the defendant company received the initial correspondence from the plaintiff asking to be allowed more time to submit their detailed claim.
We have all of that. We have all of that, Mr. Mendes.
Yes.
Your basic point here is that the material that was disclosed was sufficient so that the insurer had the information that was necessary for it to make any further inquiry that it wanted or to get any further details that it required. Is that it?
Well, there was a claim form submitted in time, that is to say within the 15-day period. It did not contain all of the information that was required. That information was eventually submitted on the 4th of October. So it was submitted outside of the the full particulars were submitted outside of the 15-day period. But on the 6th of September, an application had been made for an extension of time. And condition 11 envisages that time can be extended. But what happened after that is, after the claim, the additional information was submitted on the 4th of October, the insurer's agent requested further information on the 4th of December.
Yes. Yes.
That is to say, the accounts and so on, which were then provided. And then those very accounts were used by the insurer to deny the claim.
We have that, Mr. Mendes.
Yes.
We have
so
that. What I am intrigued by, and I would like to get the response from your friends opposite, is whether condition 11 can be applied literally as it stands. That is to say that you must give full particulars within 15 days. In this case, the insurance company took possession of the property for a certain period of time. About a week or so, was it?
They had it, yes, for about maybe just less than a week.
Right. So had they kept possession of the property for 15 days, then there would have been no opportunity for the insured to go and investigate and provide the full details. So, as I said, I'm interested to hear what the other side says. But it seems to me that it's very difficult to interpret condition 11 in a literal way, which doesn't allow for any possibility for an extension, wouldn't you say?
Yes, Your Honor, but the further point that we make in this case is that there having been an application for an extension of time, and the insurer, through their agent, requesting further information in December, taking that information and then using it against the appellant to prove arson, they must be taken as having extended the time. And therefore, having extended the time, they can't now say, I'm coming back and relying on clause 11. Because even though they didn't respond and say, yes, I extend the time, they asked for further information and continued their investigations.
Yes,
And
thank you.
therefore, it in effect extended the time.
Yeah,
But,
they were
I mean,
having it both ways.
Exactly on.
Yes. You want to
Exactly.
proceed to the arson point?
Yes, thank you very much, Your Honor. The first point that I'd like to draw to your attention, Your Honor, is that the judge at page 750, at paragraph 277, in making a finding that she inferred from the facts that the appellant had burnt down the building. She said at 277, I'm asking my learned friend, Mr. Hackett, to bring it up. She said, I also considered the fact that Mr. Mohammed lied about the bronze Buddha, which at the time of the fire appeared to have been removed from Morecambe House. I also found Mr. Mohammed to be an untruthful witness in relation to other matters. He stated that the premises were not equipped with fire alarms. However, his employee, Mr. Franklin Brown, stated that the property was equipped with smoke alarms. In fact, as you will note in the submissions, Mr. Mohammed had in fact said in his statement, which
Mr. Mendez,
Yes,
I'm sorry to interrupt you, but can you confirm that this is an area which involves findings of fact?
Well, certainly, I'm saying, but the point I'm making is that she made it. The point that I'm making is
No, sorry,
that she
no,
made.
before you go on to make that point, can you confirm that this is a situation where you are confronted by concurrent findings of fact?
It's not necessary, I'm respectfully submitting, to resolve that issue on this point, because what I'm saying is I'm accepting for the purposes of the argument that the judge made findings about the credibility of Mr. Mohammed. I'm accepting that. I have already pointed, to answer your question, is it that the court cannot at all examine these findings of fact? I'm respectfully submitting that yes, you can, if it is demonstrated that the judge did not use her position as trial judge properly. For example, if there's other evidence that she failed to take into account in making her findings. Now that is just traditional law, but I'm not on that at the moment. I'm just making the point that she had made these findings about his credibility. And she says, I took into account that he's an untruthful witness in coming to the conclusion that he set fire to the restaurant. That's basically what she's saying in this paragraph. And my submission, and this is a matter of law, that the mere fact that you find a witness not to be credible does not take the exercise any further. It does not allow you to make a finding that ipso facto this person is not a truthful witness and therefore they committed arson. And in that regard, I'm asking you to look at the decision that we had sent up belatedly. This is the decision of Thompson against the Government Insurance Office of New South Wales. And if I can ask Mr. Hackett just to blow it up a little bit. Yes. And you will see towards the middle where the word credibility is underlined. Third, whilst I concede that the credibility of the plaintiff has been attacked successfully in respect of a number of matters, and whilst I am firmly of the view that in respect of significant matters, both the plaintiff and Mr. Sitman were deliberately untruthful, I must bear carefully in mind the consequences of these findings and the limited use which can be made of the fact that a party told lies. Principles are conveniently set forth in Arazo against our RMA Insurance. Hadley J.A., with whom Mahoney and Priestley agreed, said, although the judge's adverse findings against the partners and their wives on credit cannot be disturbed, these findings provide no basis for any positive inference of their involvement in arson. It has been established since Jack against Small that disbelief of a witness's evidence does not furnish evidence to the contrary. So I'm simply making the point that the fact that you find that a witness is not credible is not a finding which by itself can assist you in inferring that they committed arson. So that's the first point that I wanted to make. The second point that I wanted to make is in relation to the judge's finding that that one of the factors that she took into account in concluding that the appellant had burnt down the restaurant was that the appellant was in financial difficulties. That is to say, that it had made a loss during the course of the year. Now, you will see in her judgment that she refers to the evidence of the witness, Ms. Clark, who had analyzed the accounts, and but she did not examine the other evidence that had been put forward by the totality of the evidence that had been put forward by the appellant, which is, one, that the appellant, over the period before 2006, to the point in time when the restaurant was started, spent over 8 million Barbados dollars, some of it the personal money of the directors, the shareholders of the appellant, some loans from the bank, totally refurbishing what was an old and dilapidated building. So they refurbished the building over spending all of that money over the period 2006 going into 2007. In 2007, Mr. Mohammed reduced the insurance coverage on the building. He was meeting all of his loan repayments. All of that is in evidence. And then, and the evidence was as well that, and this was not challenged, all of this is not challenged in cross-examination, by the way, Your Honor, that he had expected to make a loss in the first year because that is normal for a startup restaurant business. That you,
I seem to recall, Mr. Mendez, I'm sorry, I seem to recall that all of what you're saying is before us in the written submissions, is it not?
Thank you very much, Your Honor.
Thank you.
Yeah, so that the point that I'm making is that the learned trial judge and the Court of Appeal did not take into account all of these matters in assessing whether there was a motive to burn down the building. And that's basically the point that I'm making. Again, yes, Your Honor, moving right along. The other point that she took into account was that Mr. Mohammed was on the premises. I make 2 points to you. The first is that the apartment that he was occupying was one that it was an annex that they had built with the monies that I've aforesaid, and Mr. Mohammed was in the building that night. The building is to the north of the restaurant.
Just a minute, Mr. Mendez.
Yes, Your Honor.
All of these points, factors, which in your view tended to show that the appellant could not reasonably have been found to have been involved in arson. Weren't those points made in the case when the experts were being examined? Were they cross-examined on these points?
Well, Your Honor, the experts did not give any evidence on who burned the building down. The experts only gave evidence on the fact that, on the question whether the fire was deliberately set.
Wasn't any evidence given to suggest directly that the appellant was or may have been involved, was involved in the burning of the building?
The evidence was all inferential. One was, and this is what the judge accepted, that he was in the annex, that the keys had been handed to him that night. The restaurant had been closed up and the key had been handed to him that night. But there was no direct evidence, if that is what you're asking me.
Okay.
And the experts did not express any opinion as to who burned the building down.
What is there in the pleadings of the respondent on this issue as to who burned down the building?
they pointed the finger directly, of course, at the appellant and Mr. Mohammed.
Okay, well then,
Yeah.
if they pointed a finger directly at Mr. Mohammed, wouldn't there have been an onus on Mr. Mohammed to cross-examine anyone who gave any evidence from which it could be inferred that he was responsible to make these points that you are making?
Well, Your Honors, I'm just trying to remember, but there is no one who gave evidence. There's no one who came forward and said or even suggested that he did it.
No, but you said the pleadings suggested it. The point I'm getting at is the pleadings suggest that they point the finger at Mr. Mohammed, and the respondent seeks to avoid the policy on that basis. They put forward their witnesses. Well, Mr. Mohammed knows that this is one of the grounds on which the respondents are seeking to void the policy. No questions are apparently asked about these issues, tending to show that the suggestion that he may have been involved in the arson is ridiculous because of A, B, C, D, E, F. But when the judge makes findings that suggest that he was involved, then you now say, well, the judge didn't consider these issues.
Well, I'm saying, Your Honor, that I was answering your first question, which is whether Mr. Mohammed's lawyers put to any of the witnesses what I am saying.
Yes.
And the point that I am making is that the witnesses that were put were not witnesses to whom you could make these points. There were witnesses, for example, one of the employees who had given a statement simply saying that I locked up that night and I gave the keys to Mr. Mohammed and I left and so on. Now, those facts were not in dispute. So there was nothing to put to her because she wasn't accusing Mr. Mohammed. There was no case to put to her. She was a witness in the case. The experts who gave evidence did not point, except in relation to the Buddha, which they said, well, they couldn't find the Buddha and so on, and therefore that's an indication that the person to whom the Buddha might have had special value would have been the person who burnt it down because they removed it. That was their evidence. Now, as far as that point is concerned, the judge found that the disappearance of the Buddha, or the fact that they couldn't find the Buddha among the debris, was not sufficient to suggest that Mr. Mohammed had moved it, or anybody else had moved it before the fire. So that was rejected, that piece of evidence. But all of the other bits of evidence, that he was in the annex, that he had the keys, all of those are issues of fact that are not in dispute. The question is, what inference do you draw from those issues of fact? One of the issues of fact, for example, was that they found that the breakers were turned off. Yes, that is a fact. The breakers were turned off. The question is, who turned them off? And what we are saying is that when you look at the evidence that was before the court, for example, in relation to those breakers, the evidence that the respondent itself put before the court was of a statement by an electrician who Mr. Mohammed himself asked to go and examine the breaker box, and he reported that all of the breakers were in trip position. And we submit that if all of the breakers were in trip position, it must have meant that they were on in order to be tripped. So that the theory that the breaker was turned off before the fire in order to disable the fire alarms, that could not be made on the evidence. And this is what the judge found. She found as a fact that the breakers were turned off before the fire. And as a matter of fact,
so your basic argument on this issue is that unreasonable inferences were drawn from undisputed facts.
That's correct. So that's the point. So it's not a question of putting it to anyone. Those were the facts that were before the judge. A lot of the facts that we refer to in our submissions are not facts that she even mentioned. She didn't take these things into account at all, but it was all there. On the question of so for example, she said that the experts said that the breakers had been turned off before the fire. But when you look at their reports, they never said that at all. Mr. Zoe didn't talk about that issue, and Mr. Simpson said only that a question arises. Who turned it off? And he never said it was turned off before. And the evidence, we also point...
We need to press on. We have all these points, you know, Mr. Mendes. We have all of them in the submissions.
All I can do is to provoke the court so that I can find out what is troubling you, so that I can answer. So I have to mention these points until I discover exactly what it is that I need to refer you to. Yes, Your Honor.
What is troubling me is the determination by the trial judge that she accepted the evidence that there were 2 seats of the fire. That seems to have been a major factor, and I don't know that I see anything in your submission which addresses that. Help me.
Well, Your Honor, that was the evidence of the experts, and that is a finding of the judge. We have, if you will, sought to chip away at the experts' findings by making certain points that they didn't bring an electrical expert and so on. The point that I wish to make is that even if the court were to, even if there is no basis for overturning the findings of the judge, that it was deliberately set and in 2 places, that does not establish that the appellant did it. And that's our point. Establishing that it was deliberately set. Yes.
I appreciate that, and
yes.
that's all I wanted to know, that there is not anything in your submission which says that the judge erred, misdirected herself in finding that there were 2 seats of fire. I know conclusions flow from that. I'm not asking about that. I'm just asking the fact.
Yes, well, what I'm saying is that in our written submissions, we do make certain points about that evidence. For example, that the experts did not take any samples to determine whether what the accelerant was and so on. That kind of thing.
You chipped as well as you could have chipped. But
yes.
I am simply left with what remains after the chipping.
That's correct, yeah.
Which is, you say there are reasons why that finding, that the conclusion reached by the experts ought not to have been believed by her. I understand what you're saying for these reasons. I just want to see if there's any factual matter to which you can point which says that they were wrong. Thanks.
But one of the points that I would say, however, is that the experts, Mr. Zoe in particular, he had found that one of the seats of the fire was at the north of the building. And the annex in which Mr. Mohammed was is close to the north of the building. So what the evidence was, and this is what the judge effectively accepted, is that Mr. Mohammed set fire to the building, the big building at the north, right next to where he was staying.
That's in your written submissions as well, Mr. Mendes?
Thank you very much, Your Honor.
I rather suspect, with respect, that your time has long gone, and I think
it may or may not be
subject to the President, if I may.
Could I just use it? I'm sorry.
If I may, subject to the President rules, I think your time has expired.
I think so, Your Honors. It's now 11:30, but I didn't start at exactly at 10, and I have an hour and 20 minutes. But whatever. Could I just use 5 minutes to refer you to one authority, Your Honor?
You have 2 minutes to tell us about the authority.
This is the case of Russell against NRMA Insurance, which is 4533. And I'll ask Mr. Hackett to put it up very quickly. And you'll see that at 10, the note 10 there is a reference to a finding by the trial judge that the witness was not credible. And then at the note 25, there's a reference to this, but as His Honor rightly said, proof of motive is not enough. In the first place, there are few people who do not need extra money. In the second place, the motive is a very uncertain guide in deciding issues of magnitude. I'm just referring that to the trial judge had found that there was financial motive for burning down the place because of the restaurant wasn't making money. At just above line 35, in the third place, there are countervailing factors in the present case which would weaken very considerably the force of any motive. And we say the same thing in relation to the financial factors which I've referred to already. And just above line 45, they say, but if the second step in the reasoning is doubtful, the third is unsupportable, there is no possible reason to limit the suspects to an accomplice, a thief, and a drug addict. The possibilities are endless, at least as probable as any of those three business rival, etc., etc. The point is, and this is the point that I'm making, and if you go to the next page at line 20, the court says, all in all, with so many questions left unexplored and so many loose ends untied, I am of the view that no matter how unsatisfactory the plaintiff was, and even granted the existence of a motive, the court cannot reach the requisite persuasion that the plaintiff was responsible for the fire. My point is that having regard to the evidence I've put before the court, there were a number of questions which had been left unanswered, and despite the findings that the appellant was untruthful, it was not sufficient to come to the conclusion that he was responsible.
We have that, Mr. Mendes.
Is Russell in your authorities? I don't recall.
It was in a supplemental list,
Okay.
Your Honor.
Thanks.
Thank you, Mr. Mendes. We really must bring your submissions to a halt.
Thank you very much, Your Honor.
We thank you for them. Mr. Ford? Okay. Mr. Ford, we'll take a 5-minute break before we begin your submissions.
Thank you, my lord.
All rise. for the Honorable President and judges of the Caribbean Court of Justice.
Yes, Mr. Ford, please proceed.
Okay. Lord, I think it is first necessary for the court to remind itself of the principles which guide it where they're faced with the issue, where it is faced with the issue of concurrent findings of fact. Lord, Your Honors, in the case of Todd, which is found at page 3986 of the record, Todd and Price, 3986, at paragraph 43, this court stated that there will be limited circumstances where an appellate court can interfere with findings of fact made by a trial judge who has had the advantage of seeing and hearing the evidence. It goes on, we held that an inference can only be justified if it's a factual conclusion, if a factual conclusion is one that no reasonable judge could have reached. Your Honors, also in the case of Ramdial, which is found at page 2156 of the record, this court, at paragraph 46, paragraph 45 stated that it is only in exceptional circumstances that we would review concurrent findings of fact of the courts below. And it set out some circumstances. But Lord, Your Honors, what is also interesting, and you should remind yourself of paragraph, what is your finding of fact, as mentioned in paragraph 46 of the judgment. Former President Byron considered a finding of fact as distinguished from a perception of facts. And he went on and he said, it is a finding of a specific fact or perception of fact that a court is called upon to decide on the basis of credibility of witnesses. When this is the position, the appellate court must exercise caution and have a rational basis from differing from the trial judge. On the other hand, the court may have considered a situation where the dispute of proper inferences. What we say in this particular case is that there were finding of specific facts by the learned trial judge, and those facts were properly considered and independently considered by the Court of Appeal, and they all came to the same conclusion.
Mr. Ford, could you please just remind me of the case you referenced just now, attributed to President Byron?
Oh, the case is found in, the case I refer to is page 215 of the Byron's decision is really the General Electric Services Limited against Isaac Peters, Grenada, which is found at page 2174 of the record. In Ramdial, he refers to it.
Thank you.
Okay. And once on that note, on the thing I could clear the record, in the Court of Appeal's approach to concurrent findings of fact, the court is reminded that at paragraph, that at paragraph 21 of the judgment, which is found at page 278 to 331 of the judgment of the record, the court was guided by the opinion and advice of Justice of Appeal Burgess, as he then was. And he stated at paragraph 20, this is what guided the court. Where an appeal is on a question of fact, the settled law in our jurisdiction is that a distinction is to be drawn between a perception of facts and the evaluation of facts, or stated differently, between primary facts and inferences from primary facts. The process of finding primary facts involves the assessing of the credibility of witnesses. So the point I'm making is the appellate court, in reviewing the findings of fact, was guided by settled principles. The first finding of fact which was made by the learned trial judge relates to the failure to disclose the cancellation of the Gulf policy. And the learned trial judge dealt with all of the evidence between paragraphs 58, 51 to 51 and concluded that the policy that the appellant failed to disclose the cancellation of the policy. That was her finding of fact. It is interesting to note as well, I find the paragraph. Paragraph 78 of her judgment is also informative, and a question was raised. The evidence of the expert evidence is, in many cases you would use, with individuals, you would use something called a broker slip. That's the clear evidence. Or alternatively, you may use the proposal form. In the case at bar, the broker slip was used, and that formed the basis of the contract, and there was no need for a proposal form. So where you effect your insurance by way of a broker, there is no need for a proposal form. And even if there was need for a proposal form, your broker, as your agent, he completes that form. Right. So, but the point is that having examined all of the evidence, and the particular part of evidence that I find to be quite interesting, at paragraph 62, the learned trial just makes the point in relation to Mr. Mohammed. While accepting under cross-examination that Hobson's letter suggested that the policy had indeed been issued to O'Meara, and while also agreeing that the stamp duty is paid whenever a policy is issued, and in this case there was evidence that the stamp duty was paid, so there must have been a policy, Mr. Mohammed doggedly refused to accept that a policy had been issued to O'Meara by Gulf. So she looked at all of the evidence, she looked at his evidence, and she concluded, yes, a policy was issued, and you failed to disclose the policy. The cancellation. I go on.
If I may ask, in your view, is it sufficient that the fact the policy was cancelled in the classification you're using? is that sufficient for the insurer to void the policy?
My answer is yes.
How would you reconcile that answer with the test for the avoidance of the policy, which is described by Sir David Simmons in Joseph against Clico? In that case, Sir Joseph said that the test is the one to be applied from pan-Atlantic insurance. And in applying that test, one must first of all identify whether the non-disclosed fact is material, and if it is material, then one has to show that the insurer was induced by the non-disclosure into entering into the policy. So how is it that mere non-disclosure of what you call a material fact is sufficient to void the policy?
We first say that you're under a duty. Let's deal with materiality. In terms of materiality, the learned trial judge took the test, says that she is in, I'm trying to find the page, that she is entitled to determine materiality by the use of expert witnesses, her own, let's find the test. Well, I'll find the part of the judgment. The test for, how do you determine?
Tell us in your own words.
How do you determine materiality? And what she is saying, you can rely on expert, you can rely on your.
And what did the judge do? What did the judge do?
What did she do? What she says is cancellation. The expert evidence is once a policy has been cancelled, it affects the mind of a prudent insurer. In the event there is evidence that it is cancelled for some reason, put it this way, if there is cancellation by itself is going to affect the mind of a prudent insurer.
Irrespective of the circumstances surrounding the cancellation.
Yes, it's what we say.
Okay, so that's your view. Okay, so we have that.
And then we will say, it will be then be incumbent.
Mr. Ford, sorry.
Hello.
Yes, Mr. Douglas, Mr. Mendez, suggested that you both agreed on the test. The test for materiality was agreed, was accepted and agreed by both of you. That you didn't, in your case, present any test other than the test which he was applying. I have a little difficulty in identifying what tests you were applying in this case. How do you, what tests did you use? The test that my brother Anderson referred to, which is the Joseph and Clico case, because in that case, Sir David Simmons applied the test of the majority, and as we know, there is a test of the minority as well. So could you give us some intimation as to what tests we're talking about? Because I don't think you can answer, I think you've established evidence of non-disclosure, but that by itself is not enough. You still have to prove that it was material. And the question which I understand my brother to be raising with you is, what is the test of materiality? I'm still struggling to find out what we should be looking at to decide whether non-disclosure was material or not. Thank you.
Paragraph 2 of the judgment, the test applied by the judge is that a fact is material if it would have effect on the mind of a prudent insurer weighing up the risk. And then she goes on, put another way, a matter is material if it would influence the mind of a rational underwriter governing himself by the principles and practice on which underwriters do practice. That's the test she applied.
Is that the Pan-Atlantic test? Of the majority?
Essentially, that's the test set in Joseph. That it would influence the mind of a rational underwriter governing himself by the principles and practices.
Yes,
and what we are saying,
but is that the totality of the test? I mean, I agree with you that that seems to be the majority of what the majority view in Pan-Atlantic. But Sir David went on to say that there's a second stage to the test. So the first stage is that of materiality, i.e., would the fact have influenced the judgment of a prudent underwriter? If it would, it's material.
Correct.
Okay. So if it's material, the next stage is whether it induced this particular underwriter to enter into the insurance contract. So that's the second stage of the majority test, if you will. And both stages were accepted by Sir David in Joseph and Clicquot. So what I'm asking you then is whether simply to say that the judge found that there was non-disclosure is sufficient. Or would the judge not have had to have gone on to say and to find that A, there was material non-disclosure, and B, that material non-disclosure induced the insurer to enter into the contract?
My recollection of the evidence, and I'll find it, is that the evidence of Mr. Nigel Adams, who was the manager, when it was put to him in relation to the non-disclosure, he said that cancellation, debt, and these matters affecting, I'll find the exact evidence for you, would have affected the mind of guardian, the prudent insurer, in taking on that risk.
Mr. Ford, if I
that
may.
was the evidence of the manager. That the prudent manager.
Affect the mind of the.
Of the prudent manager.
Sorry, of the prudent insurer in what way? Did it have to be conclusive evidence? Would it, as I think the appellants are suggesting, that it is material only if it would affect the decision which the hypothetical insurer actually would make, which is sorry, is that the correct? Is that the test that you are applying?
That it would affect them. Yes, it is. And what we are saying is that the cancellation by itself goes towards the hazard, and without more, if you simply cancel, if you disclose, if the cancellation is not disclosed, then I cannot go further and inquire what is the reason. So cancellation by itself.
Mr. Ford, Mr. Ford, am I correct in believing that the majority decision in Pan-Atlantic, and I'm not suggesting that this is going to guide us or not guide us, but am I correct in thinking that the test, which was the test of the majority, was that the circumstance didn't have to have conclusive effect on the judgment of the insurer? All that was necessary is that the insurer was put on inquiry so that it would, in the majority's view, it would not be necessary for the thing which is not disclosed to have influenced the decision which would be taken by the hypothetical prudent insurer. Am I right in believing that?
That's my understanding of it. Because it robs the insurer of that opportunity. to inquire. What you are seeking to do, since the contract of insurance is such, I do not know about you or your business, you should not be placed in a position where you can rob me of my right or of my right to make an inquiry.
Okay, so if I understand you correctly, because I think you need to move on from this cancellation point, your submission is that irrespective of the circumstances surrounding cancellation, the mere fact of cancellation should be disclosed because, as the majority in Pan Atlantic said, it is something which would affect the mind of an insurer. It could lead them to other inquiries. Is that your submission?
Yes, it is.
Well, then please move on.
Thank you. So in respect of the other...
Mr. Ford, may I ask you this question? So the mind of the insurer can be influenced by not knowing what was kept secret, so to speak. But how can the mind of the insurer be influenced? For example, the insurer could have said, had I known this, I would not have entered into any policy or whatever. Or he could have said, had I known this, I would have asked for other conditions, higher premium, or so forth. Does that not make a difference? Just asking. Huh?
Repeat the question, I'm not getting it.
Well, the insurer could have said, knowing now what he didn't know, this would have influenced my mind in the sense that I would not have entered into any relationship with Apsara in this case. Or
yes, he could have said that.
Or it could have influenced my mind in asking a higher premium or other conditions. There are different ways how the mind could be influenced. So my question is, does that make any difference?
The fact that there are other ways that your mind could be influenced by premiums does not, in my view, take away the right not to avoid the policy. It could have been, but I'll start with the failure to disclose, and in the policy itself, the failure to disclose gives the entitlement to rescind the policy for failure to disclose.
Yeah, it interests me because, well, this is one of the few contracts in the common law where the reigning principle is good faith. As you know, in the civil law, that is the reigning principle for every contract. And so good faith has two sides. So it could also be said maybe if the only consequence would have been that they had asked for a higher premium, just suggesting that, then it would not be in good faith to withhold any money. That could be said, because if good faith reigns the contract, then there are two sides to that. Just interested in knowing what you think about that.
Yeah, my response to the good faith, since the insurer does not know the insured, the good faith is more placed upon the insurer to tell me all that I know about you so that I can make a determination. It does not mean that I have the insurer have to tell the insured all you know about me before you come to my company. I see the good faith the other way.
Well, you see it on one side.
You have the insured to let the person who is going to be at risk.
I understand that. I understand that, and clearly that is part of the good faith. But there is another good faith on the other side. But anyway, I just wanted to get an idea what you thought. Thank you.
My other part of the good faith is if you disclose and the event happens, I pay you in good faith.
Yeah, proceed.
In terms,
please proceed.
In terms of the other matter, the OMIRA policy, there is no doubt again that was not disclosed. It was a specific finding of fact. My friend has argued that in relation to the OMIRA policy, that the pleading was one of fraud. But if you look at the pleading, in the amended defense, the pleading, it was fraud or baseless. So to say that having not established fraud, the defendant, the respondent could not make good upon its claim is totally incorrect. It was fraud or baseless. And then the facts reveal that the term, the claim, having not been paid, it could only be concluded that it was baseless. If the claim had basis, it would have been paid. So the defendant would have made. Insurance companies do not refuse to pay a claim that has base. So,
but Mr. Ford, I think what Mr. Mendez is saying is that the claim was based on a particular ground, and that ground was not found to be substantiated. In other words, it wasn't pleaded. The issue had to do with the shrimp, whether the shrimp was fit for human consumption, etc., etc. And as far as that was concerned, that wasn't established. So, you know, there was no. Yes, sorry. This is if we're talking about at cross purposes.
Yes, possibly. At page 114 of the amended defense, the plea is that the Omer Foods made a fraudulent and or baseless claim against the insurers. We were unable to establish that the claim was fraudulent, but the evidence suggested it was baseless.
What was the claim related to?
What was the claim related to?
Or what was the claim?
The spoiled shrimp. A claim was made for monies in relation to shrimp. At the end of the day, the insurance company did not pay those monies. That's a fact. And if you make a claim and I did not pay the money, somewhere in there the claim was either misconceived or baseless.
So if it was that he was not really making a claim in respect of the shrimp, then you would say then that the decision is not relevant to the claim that he was making.
If he was not, let's put it away, any claim which he make, any claim that the insured makes and was not paid or honored, that should be disclosed, because it would affect the mind. The insurer does not know you. If you're in the habit of making claims from other insurers, it would affect the prudent insurer. And what we say here, in this particular one, the claim, this particular claim was not paid and it was baseless. As I understand the respondent, his contention is, you did not make out the case for fraud, so that's the end of the matter. And we say, no, you don't have to make the end for fraud. The similar argument relates then, as I've said before, on save time, that there's no evidence that the debt to the Agricultural Development Bank was disclosed. And to the effect that it was not disclosed, we use the same arguments in relation to blow. So that's the non-disclosure point. In relation to the condition, and the point I must say is that all of these matters which were considered by the learned trial judge were also considered by the Court of Appeal. They did not just rubber stamp the decision or the findings of fact. And indeed, the claim against Maritime is found at paragraphs 41 to 53 of the Court of Appeal, of the decision of the Court of Appeal. In respect of the breach of Condition 11, where is it?
Mr. Ford, before you go to condition 11, there's a question which is sort of intriguing me. The question is this: I should put it differently, must non-disclosure result in the insurance company being able to avoid the contract and nothing more? Is there anything in between avoiding the contract and the non-disclosure? By way of remedy. By way of remedy.
If the policy provides that that is the only remedy, then a third party cannot impose another remedy. The parties have agreed what is the remedy. I totally agree that the parties were at liberty to determine that there could be other remedies. But the parties decided, let's put it another way, in any contract, interest, whatever it is, the parties can determine the relief. And the court should not rewrite the contract to give other relief.
But Section 21 or 22 of the Marine Insurance Act in Barbados, and they're talking about Barbados, says that if there's non-disclosure, the insurer can avoid the policy. Does this mean, it doesn't say the policy is void, it says the insurer can avoid the policy. Is it possible to have a remedy in between avoiding the policy and the non-disclosure by the insurer? I refer to my brother Witt, who raised a question with you about the good faith operating in both ways. You seem to be suggesting that the insurer is in the kingpin position. So I'm wondering, I know that you'll find very few cases.
I'm not so suggesting, Your Honor. I am suggesting that there is nothing in the contract which suggested any inequality of bargaining power or anything, notwithstanding the terms of the Marine Act. The parties independently agree what is the remedy. I do not think it will be right then to go back to the Marine Act and the Act and say, oh, but there is another one where the parties independently agreed upon the relief.
Yes, but the basis of the non-disclosure and avoidance of the policy is statute. Parties cannot alter the effect which Parliament has decreed. But don't let's belabor that. What I wanted to find out from you is that if every time an insured does not disclose some material fact, does it follow inevitably that the insurance company is in a position to avoid the contract?
Let's put it this way. What the relationship between the parties is governed by their contract. And so long as your contract is not contrary to the legislation, it is valid. The legislation does not debar avoiding the policy. All it does is suggest that there is another remedy. So if I make a policy which says that it comes to an end, it is not inconsistent with the Act because the Act says it may come to an end. So what I would suggest is that the insured go to the insurer and says, well, look, I don't like this term. The Marine Act says may. There's no need for you to sign on to shall. So we are not signing that policy. We go into another insurance company. But having signed the policy and agreed to the terms, it's like one bank offering an interest rate at 10% and another one offering at 5%. You take the one at 10 and says, well, other people offer at 5. Okay. It's a contractual agreement. Okay, so long as none of those interest rates are contrary to the Central Bank Act, then you can do it.
Yeah, thank you very much.
Yes, thank you. But Lord, in terms of the condition 11, which is a little confusing. My friend seeks to employ a term into condition 11, and the term itself which he seeks to employ is uncertain. Find the term. He seeks to employ, the respondent seeks to employ a term, find your submission, that the decision, let me find it here. Where it is. The employee term. That to the effect that the insurer should act reasonably in exercising his discretion. Worth that effect. I'll find the exact words. So, clause 11 provides that you should submit your claim. Is this a permission? Yeah. He says that clause 11, there should be an implied term that the respondent should act in good faith and should extend the term. I will start off by saying two things about that. There was no plea of an implied term in the court below. Clause 11 was fought solely on waiver. Had there been a plea that there would have been an implied term, a prudent lawyer would have made an inquiry for further and better particulars. Please set out all facts and conditions upon which you rely to the implied term. So you would have denied.
But Mr. Ford, this is the first time I have heard introduced into the discussion the concept of implied term. I've never, maybe I missed it. I did not hear Mr. Mendes indicate that they were relying on an implied term. What I understood him to be saying is that on this face, and given the factual circumstances, namely that after the time the 15-day period had elapsed, this submitted material, which the insurance company used as part of its arsenal to deny the claim, the insurance company couldn't have it both ways. That it couldn't, on the one hand, penalize the appellant on the basis that it had not submitted this material within 15 days, and on the other hand, use what was submitted subsequent to the 15 days to deny the claim, and that the only way in which one could rationalize that uneven-handed approach is that the insurance company had waived the 15-day period. That is what I understood him to be arguing. I did not understand him to be arguing that there was an implied term.
With the greatest respect, I think you misunderstood him. At page 34 of his submission, he says, it is respectfully submitted that condition 11 is to be read, is to be subject to an implied term, that the respondent would not arbitrate, and all of the cases which he cited cases which show that term should be implied. So much so that the Court of Appeal...
But what is wrong with that, Mr. Ford?
What's wrong with that?
Yeah, because I raised the same point with Mr. Mendes before. Your client was entitled to take possession of the insured property. Was it not? And did it not do so?
For a period of time?
For a period of time, yes. Is there any limit in the contract on the period of time for which the insurance company could take possession of the property?
I don't recall it. I will check it.
So it is possible then that the company could have taken possession of the property for 15 days or 20 days?
Yes, it is possible.
Okay. So in a situation where the insurance company has taken possession of the insured property for, let us say, 15 days, surely it would be impossible for the insured to go in, investigate, and present a claim of the particulars of a loss sustained. And therefore, is that not a basis on which one could argue that there is, or there should be, an implied term allowing for the extension of time within which the insured can provide those full particulars?
Well, my response is simple. Firstly, an implied term was not pleading. You can't just get an implied term by saying there should be. One, that's the second point. In order to determine whether the insurer acted reasonably or not, one must have in hand the request for an extension of time. And I will take...
There was a request for an extension of time.
No. That's where we get into error. Oh, that's where the problem arises. I'll take you to the judgment of the Court of Appeal. Okay. No such letter was ever provided in evidence. Find the paragraph. What Mr. Mohammed said that he made at paragraph 60 of his witness statement, he said that there was a letter which requested, the judgment itself, there was a letter seeking an extension of time. Your Honors, I will take you to paragraph 80 of the judgment of the Court of Appeal, which is quite instructive. The Court of Appeal said, no, the one with the letter. The Court of Appeal stated, I'll find the page, that there was no such letter. That the Chief Justice said he's perused all the documents and he has not found such a letter. You can find it for me. And what we say, with the paragraph. Well, I'll find it before I proceed. The important point is being made is that if you do not have a letter, it's at paragraph 87. At paragraph 87, in our view, the respondent made no equivocal representation that they were not relying on the time bar, despite the appellant's suggestion that they wrote to Guardian for an extension of time. No evidence of this has been presented to the court. So the point I'm making, if your request, I don't have the letter in front of, if you don't have a letter, if your request was an extension of 9 months, then it would be unreasonable. In order to determine whether the respondent acted reasonably or irrationally, one would have to have in front of it, there was a request for an extension of 2 days, and they refused to do so.
So can we settle on this then? That if there was no evidence of a request for an extension of time to provide the full particulars, then there was no request. If there was a request, if the evidence shows that there was a request, would it not be inconsistent with the good faith nature of this contract of insurance not to provide an extension of time? Can we agree on that?
No, we can't agree on that. We will have to agree the time, the extent of the request is important. Let's assume that the request for a year. Then it would be unreasonable for me to agree. So what is not only the request, is the time requested.
No, but you could respond to say that a year is unreasonable, and instead we will give you 2 weeks or a week, couldn't you?
I could also say that the request is so ridiculous, for 2 years I don't intend to respond. You're so unreasonable.
Would that be acting in good faith?
I do not think to ask for a request of 2 years to be also acting in good faith.
No, but your response, I'm saying, can't you respond by giving what you consider to be a reasonable extension?
That would not be, by giving what is a reasonable extension, and then it will call into effect what is a reasonable extension. Whatever I give, you would consider to be unreasonable. What if it does not suit your request? Because I would assume that the request that you made would have been a reasonable one. But the substantive point is there was no evidence of a request at the time. And if there's no evidence of the time, then one cannot conclude that the insurer acted unreasonably. If we had evidence that he acted for a request was for a day, so be it. But then again, the wider question is, my lord, in terms of judicial review, the cases show that it is not fully accepted that the terms for judicial review, the due process, applies to all forms of contracts. In the Braganza case, the due process and the acting reasonably, they found was applicable to a contract of employment because the contract of employment was one which was grounded in good faith, in trust and confidence. But you will note at paragraph 20 of the Braganza that is cited by my friend, the cases show the decided cases reveal the understandable, at page 732, the understandable reluctance to adopt the fully rigor of the principles of judicial review in a contractual context. The public lawyers for years were trying to have those principles in judicial review transposed into business and contract law. And the cases show the judges had a reluctance. What the cases also show, in order to have that implied term, it depended on the type of the contract. So the cases show the first thing you must look at is the type of contract. But in general, there is no rule of law that the administrative principles can be transposed into implying a term into a contract generally.
Mr. Ford, give me some help here, please.
Yes,
I realize you've been dealing very fully with the matter of implying a term as to supplying particulars, etc., and the application of condition 11. The submission of the appellant refers to the case of Nasser Diab against Regent Insurance Company Limited, with which I may have had an earlier familiarity, a case from Belize.
Yes, Lord.
And Mr. Mendez quotes from paragraphs 14 and 16 of that decision at his paragraph 77 of his submissions. I'm just referring to this as a matter of convenience. And the essence of the Privy Council's statement, which engages me and on which I'd like your assistance, is the statement that in a case where notice of a claim has been given forthwith to the insurer, and where a claim in writing with the requisite particulars of the loss and damage has followed sufficiently promptly to enable the insurer to verify that the claim is a good one, it is not obvious that a failure to deliver the claim in writing and the particulars within the specified period should be treated as relieving the insurer of any liability in respect of the claim. Perhaps the specified time should be treated as directory and not mandatory. Perhaps the insurer's consent to an extension of the time should be subject to a proviso that it be not unreasonably withheld. But no argument on these points has been addressed to their lordships, and no conclusion on them can be reached on this appeal. End of quote. What intrigues me is the notion of the interpretation and the application as a matter of law of that provision. So, may I have your view on that?
Yes. What intrigues me as well is the response to the response to those arguments in the case of Braganza, which considered the case of Abu Dhabi, and that is the case that makes the point that there's been a reluctance for the court to take that view.
Okay.
And the Braganza case is an important case. It says it goes on to say that it was so done in this particular contract because it was an employment contract. But when you read the Braganza case discusses at paragraph 32 discusses that concept. So we've gone from Abu Dhabi, where the concept was first mentioned or previously mentioned, obiter, and it was fully discussed in Braganza. And all Braganza is telling you, you don't just transpose those particular terms from administrative law into contract law unless you understand the terms of the contract. They may be applicable to some contractual terms, to some contractual matters, but not all. So what the Braganza case, the Braganza properly explained the Abu case. And the reluctance of the court. The courts were not prepared, but you aren't even a good example. In some jurisdictions, and Barbados is one, you can have a claim for wrongful dismissal, and you could have a claim for unfair dismissal under the ERA. In respect of a claim for wrongful dismissal, you can't claim due process. If you want due process, you go to the ERA.
Quite frankly, Mr. Ford, those analogies are not helpful to me at all. I simply wanted to know what is your view in relation to Diab as to how to interpret that clause. Yeah?
And my view in relation to Diab is the view of the Supreme Court in Braganza. That is my view. My view, I adopt the view of the Supreme Court that it is not a wholesale transplanting. And it varies from contract to contract. So you would have to say, and to show that this is a peculiar contract, the insurance that requires.
You have answered me. You have answered me. Thank you.
Thank you. Yes, the Braganza is the answer. So it is not my view. I just adopt the view of the Supreme Court, who interpreted Abu. In relation, so that deals with the implied terms. And one of the things about the implied term, one of the fundamental things is that we said here it was not pleaded. The case was not fought on an implied term, as said by the Court of Appeal, but it was waiver. And both courts found that there was no unequivocal representation. The paragraph, the Court of Appeal dealt with it at paragraph 87. In our view, the respondent made no unequivocal representation that they were not reliant on the time bar. That was the finding of the Court of Appeal at paragraph 87. And there is no exceptional circumstances why one should set aside that finding. Likewise, prior to that, the learned trial judge made a similar finding that there was no unequivocal representation. And one must remember that the case was not being fought on an implied term. We must keep that clear in our head. The case was fought on waiver. And at paragraph 87, And the learned trial judge dealt with the waiver at paragraph 78. But in any event, one of the primary things in finding, in having, in not upholding concurrent findings is that you must come to the conclusion that the decision was plainly wrong. That is your first test of the review. You must say whether you look at it, it is plainly wrong. You don't just go and start extracting, finding the facts and look at them. When that would be the task of the learned trial judge, you say to yourself, you look at the cases I've said to you, the Privy Council's approach, limited circumstances. And you, at the end of the day, you must come to the conclusion when you, if you intend to not to upset or refuse to accept the concurrent findings, that the judge was, the courts were plainly wrong.
Could I ask you a question, Mr. Ford? It just occurred to me, is there a difference in the appellate function between the intermediate court and the apex court as far as concurrent findings are concerned?
The Court of Appeal reviews the findings of the High Court. All right, that's their first task. So the first review you will ask yourself, the appellant seeks a review of the findings by the High Court. The Court of Appeal then reviews them as it was done in this case, and what it can do, it can disturb the findings or it can agree. In this case, it agreed. When it comes down to it can disturb the findings, and you would find in the Court of Appeals, in the judgment of the Court of Appeal, they looked at each and every finding of the learned trial judge, and they said that the finding was permissible on the evidence, which is consistent with the approach given in Todd and Todd. It was consistent. There's a distinction between these 2 points. A decision is permissible on the evidence, and I myself would not have made it. The fact that I myself would not have made that decision does not mean it's not permissible of the evidence. So that's a distinction, and then you meet that a lot in judicial review.
We have that point, Mr. Ford.
We have that point. So that's the point. And in each case, it was permissible on the evidence.
You want to go on now to the issue of the arson, the alleged
so
arson?
the arson, in terms of the issue of the arson, both the learned trial judge and the Court of Appeal found that the fire was set by a deliberate act. What the experts say, and I learned that from during this case, that is highly improbable for a fire that is not deliberate to have two causes. So that guys who seek to burn cars and thing and burn houses and throw the gasoline all around the house,
Mr. Ford, let's not dwell too long on that point. The conversation, I think, on arson should be whether or not, if the fire was deliberately set, 2 points of 2 sources, is there evidence, A, that it can be linked to the appellant, and B, if there is such evidence, when you take all the evidence in the round, what part of the evidence were primary findings of fact, and what part of the evidence were inferences, and how do we approach the latter?
My response is, in terms of the finding that the fire was deliberate, that is a finding of fact, primary finding.
Yeah, no, fair enough. And if you find that based on the 2 sources, let's move past that. Let's move on to the nexus between, let's assume that the fire was deliberately set. The expert came, they said that, they say that that's what they think, what they found says. Good. I want to go to I would like you to go through with us the evidence in relation to the connection to the appellant.
Right.
Because if the
Right.
fire was deliberately set, that means nothing. That has no impact in this case. The fact that the fire was deliberately set has no bearing or consequence adverse to the appellant unless we can conclude that the appellant had a hand in it for the purposes of avoiding the policy. Don't you agree?
I agree.
All right. So let's
And what
go
say
to that. Thanks.
Right. And in examining that fact, the court must take this court, which is only looking at a record, must be cognizant of the fact that the learned trial judge had the advantage of hearing and seeing Mr. Mohammed, which you have not, and making, and so she is entitled to make certain findings in relation to her credibility.
That is
She's
only
entitled to make that.
that is only of importance if you're speaking about primary findings of fact. And this is why my brother asked you to distinguish between what primary findings of fact pointed to Mr. Mohammed as being the author of the fire, as distinct from the findings of fact that were inferences that were drawn by the judge. Do you understand?
I think I understand what I was saying. The point I started off by saying that the primary, that in terms of the fire itself, the cause of the fire, that is a primary finding, and the evidence came from the experts to support that which she was entitled. I then go on and say
and Justice Jamila has said to you quite correctly that by itself says nothing.
Yes, and all I'm saying that in relation to the linking that fire to the defendant, it is circumstantial.
So you concede that all of the evidence which was used by the trial judge and reconfirmed or confirmed by the Court of Appeal would lie in the realm of inferences that were drawn.
Totally agree with that. I can't dispute that.
Well, if you agree with that, then you have to also agree, because you're the person who quoted Sir Dennis Byron in Grenada Electrical Services and Peters, that appellate courts are in just as good a position to assess the reasonableness of those inferences as the courts below.
And I totally agree with that.
Good.
I cited and I don't dispute
President,
it.
just so Mr. Ford, wait, just so we don't have to come back on this ground. Therefore, the concurrent finding principle is inapt.
In relation to the agent who did it.
In relation to inferences.
Yes, it is.
You agree?
I agree with that.
All right. So therefore, on the question of arson, given that the fact that the fire was deliberately set is not material, given that the material evidence is the nexus, given that all of the evidence of nexus you have agreed is inferential, then there is no bar to this court reviewing that evidence, no bar based on any concurrent finding principle. You agree?
I totally agree with that.
Okay, good. Yeah.
I don't object for the sake of objecting. But what I also say, that in reviewing that evidence, you should take into consideration the judge who sat through X weeks of trial and who observed the demeanor of the witnesses, including Mr. Mohammed. That has to be in the mix. Who she found not to be credible. So I totally agree it is a subject for review, but in review, you do not discard the findings of the trial judge and the Court of Appeal, although you can review it. You can say to yourself, in our opinion, it does not lead, in our opinion, no reasonable judge would have come to that conclusion based on this circumstantial evidence. And I would submit that there are some judges, some reasonable judges who would come to that conclusion and others who would not. And therefore, the finding was permissible. Although you have the right not to uphold it, it is our submission, it was permissible on the evidence. It was considered and permissible. But I must concede, it is a matter for this court to determine, but in my respectful submission, it should not determine it in a vacuum.
Okay, so to conclude or to sum up your evidence, your submissions on the arson point, you accept that linking the defendant with the arson was a matter of inferences drawn by the trial judge.
Fully agree.
You accept that appellate courts could review those inferences to see whether they were reasonably drawn.
Fully agree.
And you say that they were in fact reasonably drawn.
That's the submission.
Okay, so we have...
At my age, I do not waste time.
No, I appreciate that.
Trying to resist arguments that are sound. I am too old for that.
Yes.
There's no defense to there's no defense. I concede. But what I say is that in your mix, you should consider the views of the trial judge who sat through the trial and who observed Mr. Mohammed. That's all I'm saying.
Yes, and I don't think that anyone can disagree with that, because the trial judge was the person who conducted the trial. So we have that submission. Is there anything else that you wish to say to us?
So in terms of delay, I think I'll deal with the point in delay in my submission that rely on those. And then in terms of delay, the respondent was not responsible for the delay. And as such, he should not suffer from the delay. And there's the case of Bond and Dunster, which I've cited, that delay by itself is not sufficient to establish that it was unfair. And I also make another point. It has become fashionable in Barbados now for persons to claim against the Crown, against the state, under Section 18 of the Constitution for delay. So it is open to him to make a claim that my case was not heard in a reasonable time, and therefore there's a breach of Section 18, as opposed to delay by itself does not make it unfair. Delay may be a breach of the Section 18 in the Constitution, but as Bond and Dunster say, delay by itself, you have to go on and show that as a result of the delay, there were certain, it has to be directly related to the delay, that the errors which you identify were related to the delay.
Mr. Ford, before you move on from the delay, I gather you're about to move on. If we are in the realm of inferences, not the finding of primary facts, inferences, in which you say, well, give credit to the fact that the trial judge saw and heard. You remember you told us that at the end, right? But what if 4.5 years after you saw and heard, you're going to do your analytical assessment and make inferences? Why should delay not be a relevant consideration where we are talking about inferences? Surely you may agree that with the passage of time of anyone, even of an attorney or a judicial officer, our recollection of these advantages that you have when you see and hear diminish. Or certainly we don't have in the record that the judge said, you know, I draw this inference, I made a note while the witness was given evidence, I made X, Y, and Z notes. It's not that. So my short question is, before you pass over delay very quickly, I want to limit your response to whether or not delay can be a relevant consideration where we are talking about inferences.
The answer is if delay can be a relevant consideration. In terms of inferences are derived from primary facts. And once these primary facts have been established without delay, it is quite unlikely that the inferences which can be drawn from those primary facts can be affected by delay.
And therefore, there is no special advantage of the trial court over us. Because 4 years, 5 years after what the trial court saw and heard, because you have the primary facts. Anyway, let's not dwell on it. I just raise it and leave it with you. Let's move along.
So the point that, what I'm saying, in order to establish the delay that it was unfair, you have to show these things, and they have not been established in the submission in relation to in paragraph 63 of our submission. We made the point: findings of fact are not automatically be set aside because the judgment was seriously delayed. From Bonner Dunster, as in any appeal of fact, the court has to ask whether the judge was plainly wrong.
Mr. Ford, let's put it this way. Delay is usually unfair to both parties. Wouldn't you agree?
Yeah, to both parties, yes. So if it was unfair to him, it was also unfair to me. I take that point. It can't be unfair. It can't be unfair to the appellant alone and not unfair to me.
Yeah, and neither side would have contributed to it.
That's the point.
In any way. Is there anything else you want to say to us, Mr. Ford?
No,
your time has expired.
Unless there are any queries, any questions you want to pose to me?
For my part, I think we're good. Yeah? So, Mr. Mendes, thank you very much for your submissions, Mr. Ford. And of course, we have them in writing so that we are sure not to have any of the points that you made elude us. Yes?
Final note, my lord, in parting, and I don't think it is I don't think it may be too material. I received some submissions last night or so from my friend. I didn't get the chance to read them. Around 1 o'clock this morning. Some cases.
If there is anything in those cases that is not encompassed by your submissions and you feel moved to provide other cases, as the case may be, then
I don't think my friend did it deliberately.
We would give you leave to do that.
Thank you, my lords.
Not submissions.
No, yes, that's just the cases themselves.
Yes. Yes, Mr. Mendes?
Well, first of all, the cases that I sent, my lord, Your Honor, cases that I referred to today, so that the learned friend will know exactly what I was relying on. Just a couple of points, if I may, just to correct the learned friend, as far as the factual record is concerned. The learned friend referred you to paragraph 87 of the judgment of the Court of Appeal, which is found at page 322 of the electronic record in which the Court of Appeal said that there was no evidence of a request for an extension of time. And the learned friend said that you now have before you a concurrent finding of fact. Well, that is not so. As a matter of fact, that finding by the Court of Appeal contradicts the learned trial judge's finding, which I had referred to the court earlier on, which is at paragraph 307 of her judgment at page 759 of the electronic record, where she said the evidence disclosed that the defendant company received the initial correspondence from the plaintiff asking to be allowed more time to submit their detailed claim. It appears that the plaintiff's letter went unanswered and that the defendant company continued to adjust the claim. That was a finding of fact made by the trial judge based on the evidence of the of Mr. Mohammed, and I just had it here and it just seems that I misplaced it. Yes, which you will find at page 1073 of the record, at paragraph 59 of his witness statement, where he said that he had made the request and he had asked for further time. Now, there was no appeal. It's okay, Clay. There was no appeal by anyone against the trial judge's finding of fact that the request for extra time had been made, and therefore it was quite surprising to see that the Court of Appeal in effect overturned it without even referring to the finding that had been made by the trial judge. So I can only suggest that it was an error on the part of the Court of Appeal, maybe because of the passage of time, not realizing that the trial judge had found that there was in fact evidence, and indeed that was not an issue before the court because there was no appeal on that. So I think that this court can take it that the Court of Appeal was wrong to say what it did because there was no appeal against the trial judge's finding, and indeed there is evidence, as I've just referred the court, establishing that the request for further time had been made. One other point that I wish to make is,
Mr. Mendes,
says, well,
Mr. Mendes,
yes, Your Honor.
Paragraph 87 says Mr. Mendes in his argument suggested that this letter was before the court. So is that true?
That's the point.
I
can't remember, Your Honor, if I had suggested to the court that the letter was before the court. I may have. If I did, I was mistaken. But the fact is that there was a finding. There was a finding of fact by the trial judge, and that's what I'm relying on. The other point that I wish to make is, Malin Friend said we did not plead an implied term. It was the insurer that was relying on condition 11 in circumstances where there was a request for an extension of time under condition 11. And our point was that the law is, and we are asking this court to find, in accordance with the Privy Council's suggestion in Diab, that there is an implied term to be read into the contract, that you can't refuse that extension of time unreasonably. And of course, in the circumstances of the case, it would be unreasonable ex post facto to refuse an extension of time when you received further information that you requested outside of the time period, and then you use that very same information against the appellant. So it is in that context that we are referring to the need to imply a term into the contract. Respectfully, my learned friend's interpretation of the Braganza case is not accurate. In the Braganza case and in the passages that I have referred to, the court was referring to the developments in the law, generally speaking, in relation to contractual discretions, not limiting it to contracts of employment. But I would respectfully submit this, that if under the contract of employment there is a mutual duty of trust and confidence, and that mutual duty can lead to a ruling that a contractual discretion must be exercised in good faith, then respectfully in relation to insurance contract, which is based upon good faith, that similarly, a contractual discretion on the part of the vest in the insurer must also be exercised in good faith, and that fits in with the learning in Braganza, and similarly, the ideas that were explored by the Privy Council in the Diab case. I say ideas that were explored because, of course, the court did not make a ruling in that case because it had not been argued. I'm respectfully arguing it now and asking the court to make the finding that I have suggested. The last point
Mr. Mendes, before you move on.
I don't know.
Just
I'll be entitled to a response if Mr. Mendes go on for another 15 minutes.
All right, can I just ask Mr. Mendes one question, Mr.
I'm entitled to 15 minutes, I believe, in accordance with court order. Yes, Your Honor.
Yeah, so your point is that the respondent having asked for the info, it having been supplied and having been relied on, it was reasonable to imply an extension of time, and this is my addition, up to the date of supply then. That would be how you would apply it in this case. So in other words, it's not a question of I'm writing to ask for 7 days or 14 days. This is an ex post facto implication based on the circumstances of the case. That's what you're saying.
Effectively, yes.
Yeah.
But in both ways, I'm saying one, there was in any event a duty not to refuse time unreasonably, and that is in fact what happened.
Well, yes.
They in fact extended time. They in fact behaved reasonably. What is unreasonable is the insurance company now trying to deny liability on the basis of an alleged breach of Condition 12.
Yeah. Okay. Thanks.
The last point that I wish to make is a general point, Your Honors, because insofar as the concurrent fact point and insofar as the general deference that is paid to findings of the trial judge, the way in which we have crafted the case and the way in which the issues have unfolded, the concurrent fact points and the deference point really don't apply. As my learned friend Mr. Ford has just conceded, certainly in relation to the arson point. But we have raised the question about delay, and I would respectfully adopt what Justice Jamada was saying, and this is a point that has been made in the cases that we have cited, that a judge sits in a trial and views the witnesses and forms certain impression of the witnesses, and then goes back and looks at the evidence, looks at the documentary evidence, looks at the oral evidence that is led, and then makes an assessment of the evidence, including the impression of a witness, and comes to a finding of fact. But if that process is happening 3 years after the fact, then the judge will have lost the advantage that the judge had in viewing the witnesses. And the point is that it is extraordinarily difficult to know to what extent there was that loss. And this is why all we are saying is that in this case, even though, of course, delay impacts both parties, certainly the appellant has been more impacted by it because his case has been dismissed and adverse inferences have been drawn from the evidence against the appellant in circumstances where the process has been flawed. The process that the judge would employ in analyzing evidence and coming to conclusions has been affected by the delay, not only in the trial, before the trial judge, but also before the Court of Appeal. And that is why the submission is that this court ought not to be relying on the concurrent fact principle, or at the very least should examine the evidence with greater scrutiny because of the delay that has occurred. In other words, if this court were to say, well, we are applying the concurrent fact situation, then the appellant will not have had its proper measure of justice, either before the first instance judge or the Court of Appeal or before this court. And that's a respectful submission. Thank you very much, Joe.
Yes, well, thank you very much, counsel, both counsel. Naturally, we would take time for to consider your submissions, and we would let you know when we are ready with the judgment. Madam Registrar, you can bring the proceedings to a close.
All rise.